And welcome to Law Call on this Saturday evening. I'm Ken Flanagan, so happy to have you in after the basketball game in law firm of Reeves Mestayer. He's my friend, he's your friend every Saturday night, one form or another. Jim Reeves, the Bulldog. Jim, I do love that promo. When do you know when to call an attorney? When do you put your faith in the insurance company? It's a question you've been answering for a long time.
Yeah, it isn't a question we've answered a long time, and the short answer is never put your faith in the insurance company. That's the truth. And so there are some cases, though, that...
Good night, everybody. Thanks for calling. I appreciate it.
There are some cases, though, that might not rise to the level to be serious enough to involve an attorney, and you may be okay trying to navigate on your own. And then there are other cases, clearly, where you're going to need help. We'll talk about that tonight, where that dividing line is. Generally, what you need to understand is if it's a serious injury that potentially or may affect your ability to earn a wage in the future, you definitely need to talk to an attorney. And the good point of that is we talk about this a lot on the case.
Sure.
It's free. You call an attorney and you talk to them and you get the advice and you say, well, I'll follow their advice or I won't, or I'll hire them or I won't. But you at least can make an educated decision.
That's right. And Jim's not just saying that, too. I have been to lunch with him and Matt many a times, and we'll be right in the middle of getting our appetizers together, and people come up and ask them all the time, and at church and civic events, I know for y'all. And, of course, coming into the office, that's what you're really talking about, coming in and getting that going. So our topic tonight is personal injury claims. When do you need a lawyer? When do you count on your insurance company? When does that conflict come in? When do you need to call Jim? But first, we are starting off with an epic email question that came in this week. This is kind of the war and peace of email questions. This comes in from Lucy. Lucy says, my boyfriend and I were in an accident. We came over the hill and an oncoming farmer tractor ran into our lane and hit the driver's side, totaling the car. My boyfriend has torn cartilage in his ribs, and I have hit my head on the mirror, and I have a 3-inch gash over my left eyebrow. We obviously have ambulance, ER, and clinical bills. It goes on, Jim. The adjuster from the other man's insurance company has contacted us and asked what we're looking for. Besides the obvious stuff like medical, lost wages, car, what is reasonable for pain and suffering? Would it be rather for us to settle out of court, or be better for us to hire a personal injury attorney? Lucy was definitely taking advantage of the website this week. A lot for you to go over there, Jim.
And I don't mean to laugh. It sounds like it's scary. These things are always scary, even if the injuries aren't life-threatening. And so, Lucy, I hope you're okay. Hope everybody's okay. Look, a couple things, a lot to unwrap here, but let's start from the end. Statistics show conclusively that people who hire attorneys in personal injury cases recover 3 to 4 times and sometimes 5 times as much as people who don't. That's net recovery after paying the attorney a contingency fee. So if you have a serious case, you need an attorney. Your outcome will be better with an attorney. And it just makes common sense. We talk about it a lot on the show, but this is probably Lucy's first time to have to deal with an insurance adjuster. Or claim. She doesn't know the law. The insurance adjuster, probably not a lawyer, but she's probably handled hundreds, maybe thousands of these cases. So it's a real disadvantage in the negotiating ability as to what your rights are, what you're entitled to. They know a lot more than you know, typically. And that usually means it's bad for you, okay? And so that's the first thing. The second thing is we talked about earlier, talking to an attorney, getting advice, cost you nothing. You can, just because you go talk to an attorney doesn't mean you have to hire them. Don't have to pay them a nickel. Get your free advice and decide what you want to do. I would caution a couple things, though. A lot of times in cases, especially if it's a significant impact, meaning there's a lot of damage to the car, not just a bump, but a significant impact, a lot of times people will develop medical problems later that they don't recognize at the time. I see this time and time again. One of the most common problems I see, since I've been practicing for 32 years, is people will attempt to settle something on their own that they think is a minor injury, and 6 months down the road, the doctor says, well, you have a herniated disc or some other type of injury. It's going to require an expensive surgery, and it's going to restrict your ability to work in the future. And guess what? If you go back and say, insurance company, it's not enough, too late, you sign the release, you cash the check, they're never going to pay you another dime. And so you're acting really out of a situation where you don't know what you're doing if you're settling that kind of case without at least talking to an attorney to determine what you may be able to recover.
Let me go over one thing, too, that Lisa said. And Yeah, you probably got an idea what your car's worth, and
Right.
you certainly know how much you're lost from being at work and your insurance, stuff like that. But she's put in that phrase, pain and suffering. And I think we've all heard that on every
Right.
television show and law show out there. And
Right.
gosh, how many commercials say that too.
Right.
But that's the big one in it, Jim. That's where really, as a layperson, maybe you can come up with the value for your car, but pain and suffering, it's just
Yeah.
a different world.
Right. In a personal injury case, and so generally in a personal injury case in this state and in most states, you're entitled to recover your medical expenses, past and future. You can count those, right? You total
Right.
those up, you put them together. A doctor talks about what you're going to need in the future. You can put a price tag on that. So you know sort of with mathematical certainty what that's likely to be. The next thing you're entitled to are your lost wages or lost earnings. Past, you can just add those up.
Right.
Okay. Future, that's going to depend on what the doctor says you're able to go back and work and do or not. Okay. Right. The other things that you're entitled to recover for, what we call non-economic damages, pain and suffering, mental anguish, disfigurement, loss of enjoyment of your life. I mean, you can't do the things if you'd like to fish before, you can't fish now. You like to hunt before, you
Right.
can't hunt now.
Right.
Those things almost impossible to add up with mathematical certainty. And so you need an attorney involved in that case who knows the venue that you would file a lawsuit in,
Right.
and what juries are likely to award on similar cases, or what they've awarded in similar cases in the
Got
past.
another email call, email question for you here. This came in for Brian. Not quite as long as the previous email question, but this one, the other one was War and Peace. This one's probably something about a white whale. Here you go. My wife fell coming out of the shower in our hotel room. I'm in a wheelchair and it reserved a handicap accessible room. The shower area was separated from the rest of our bathroom and had a rubber divider intended to keep the water from running out of the shower. I think we've all probably seen this. The divider had separated from the subsurface beneath it and raised up. However, the separation wasn't noticeable as she goes on. The whole thing laid out in the bathroom. It was flawed. It was dangerous. I have digital photos documenting all of this. My wife tripped on the divider, broke her arm. That's the bad part. Injured her elbow and her shoulder. We filed a report with the hotel the same morning. Should we wait for a response or go ahead and talk to a lawyer? Brian, great question. Jim, it sounds like a slip and fall, but it's like a little bit more than a slip and fall, isn't it?
Yeah. And so this one with a broken arm and a significant shoulder injury, I would go ahead and contact an attorney. You may not necessarily need to hire an attorney at this moment. I would go ahead and contact an attorney. They're going to be wanting for you to obtain statements from you at some point about what happened if they hadn't done that already. I can't remember from the question if that had been done, but it will be done at some point, and you need legal advice and guidance on when and how to do that. So let's talk a little bit about what these are called premises liability cases and the general rules and what makes a premises liability case viable or not. And these are, believe it or not, some of the more difficult cases to prove and win in front of juries. So everybody hears the story about a banana peel or some kind of problem or somebody slips and falls. So, and everybody assumes just because you fall on somebody's property that somehow makes them responsible. That's not true at all. And so what we have to be able to show is that there was a defective condition with the property that caused the fall, one, and two, that the property owner either knew about this or in this case, if it was a design flaw, created it, so he's giving constructive knowledge, so he knows it's a defect. And then he has a duty to either warn about the defect or correct it. Okay, so you have to hit all those elements to prevail in that case. So in this particular case, it sounds like what he was describing, as best I could tell, was probably if it was a flaw in the design and the way this shower is designed and laid out.
Right.
And that means you get past what's called the knowledge of. So if it's designed that way, they know it.
Right.
If it's a spill of water in the floor and you can't show it was there for a long period of time, then they probably didn't know it. Okay. If that helps out. So you potentially have a case there. The other thing that comes into play here with a wheelchair accessible room is whether it complied with the American with Disabilities Act standards, and how it's laid out. Okay?
Yeah. So, Charles, great question. Really do appreciate it tonight. Sounds like Jim hit the nail right on the head. Probably go ahead and talk to an attorney.
Yeah.
Bud, we were talking in the break. We have talked a little bit about slip and fall tonight. We've talked about insurance companies.
Right.
Just talked about the ADA. Let's talk about workplace and OSHA. You have a huge case along with Seth in Hattiesburg.
Right.
What's going on with that one?
Well, it's a terrible case. It's made national news, broadcast news, most of the major newspapers all over the country. It involves a young man who was working at the Marjack poultry plant in Hattiesburg and was pulled into the machine. The company had a history of violating OSHA regulations, including what's called lockout, tagout safety procedures. and were fined again just in the past week since then for additional violations.
Oh, no.
So terrible, terrible case. Just so people know, we talked a little bit about Americans with Disabilities Act. OSHA regulations, oddly enough, they're the industry standard. So most people know what OSHA, or think they know what OSHA does, but OSHA basically comes in, has rules and regulations, investigates serious accidents, and makes recommendations and sometimes requirements that employers change or modify their work procedures to make sure they're safe. And if companies don't do that, they're often fined by OSHA.
Sure.
If they do it repeatedly, OSHA can actually shut them down. And so that's sort of what OSHA sets forth industry standards. Interestingly enough, if you try one of these cases, generally the jury's never advised of OSHA standards.
How about that?
We're not allowed to talk about OSHA standards generally in front of a jury. They're evidence of industry standards, but you're generally not able to hold someone responsible for just violation of OSHA standards in and of itself. So it's a weird quirk in the law, but it's the way it is. So you can talk about
no, I didn't know that.
They're evidence of industry standards, but they're a violation of an OSHA reg generally in and of itself is generally not considered negligence as a matter of law.
It kind of reminds me of you're not allowed to tell juries many times that this company has insurance.
Same quirk. If you're on a jury and it's a significant injury, I promise you, insurance company is why you're there. Okay, the person being sued or the company being sued has insurance. Although jurors will a lot of times say, if we question them afterwards, well, there's no insurance for this? And well, sure there was, but we're not allowed to say the word insurance in front of the jury. No one's allowed to say it. Everybody dances around it, but it's an evidentiary rule that you cannot mention it, and often it'll cause a mistrial if it is mentioned.
How about that?
In the presence of a jury, even though it's there virtually every time.
Believe it or not, man, the show went so fast. Appreciate all the email questions and the calls tonight. Great, Jim, great information as always. We'll be back next Saturday night with Matthew Mestayer. We'll be talking more about personal injuries, liability, who's responsible, who done what to who, and who's responsible here on Law Call. But until then, good night.